Oh yes, oh yes, oh yes. This Honorable Superior Court of the County of Alamance is now open and sitting for the dispatcher's business. The Honorable Judge Tom Lambeth is presiding. God save the state and this honorable court. Please be seated.
Thank you, Mr. Sheriff. Good morning, everybody.
Good morning, Judge.
Let me ask the attorneys, if you will, perhaps identify yourselves for the court and any parties that you may have here.
Good morning. My name is Andrew Casper, and I'm special counsel to Secretary Mandy Cohen of the North Carolina Department of Health and Human Services.
All right, good
With
morning.
me is Lisa Corbett, who is the general counsel to NCDHHS, and William McKinney, who's general legal counsel to the governor.
All right, good morning. Thank you.
Morning, Judge.
Good morning.
I'm Chuck Kitchen. I'm here representing After 5 Events, LLC, Robert Turner, and Jason Turner.
All right, thank you, Mr. Kitchen. Glad to have all of y'all here.
And Ms.
Your Honor,
Wallace.
please, good morning. Frank Longest, I'm here in a limited appearance role. Two of my former clients got notice of this hearing yesterday afternoon by being served through me as the registered agent for Green Street Associates Limited Partnership and also Ace Speedway Racing Limited. They're both entities owned by a gentleman who lives outside Philadelphia. Those two entities, as far as Ace Speedway Racing Limited, has not had anything to do with the operation of the racetrack for several years. We provided notice to the State Department about that 2 days ago when I got served with the order. And then, yesterday, I got served with the notice and the complaint and summons for the matter here today. I tried contacting my former client in Philadelphia and found out that he's suffering from, unfortunately, the virus. And so he's not available to even communicate with. So I'm here to meet my ethical obligation as the registered agent of the corporation, but I've not been employed or engaged to speak for either of those two entities that were my former clients. So I'm asking the court recognize me only in my limited capacity, and I hope the court will allow me to withdraw at the appropriate time.
Thank you, Mr. Longest, for clarifying each of those issues. Do you wish to be heard at any point in this in your limited capacity?
Just what I said.
Okay, all right, very good. Thank you. All right, Mr. Clerk, good morning. Calling 20 CVS 1001, styled Mandy K. Cohen in her official capacity as Secretary of the North Carolina Department of Health and Human Services versus Ace Speedway Racing Limited, After 5 Events, LLC, 1804 to 1814 Green Street Associates Limited Partnership, Jason Turner and Robert Turner, defendants. I have read the file. I've looked at and read the other exhibits, so I'm ready to hear any presentation that the plaintiff wishes to make.
Good morning, Your Honor. I have a brief. Is it fine if I approach and
Yes, sir.
approach?
Thank you. Whenever you're ready.
May it please the court. So as I said, my name is Andrew Casper, and I represent the Honorable Dr. Mandy Cohen, who's the Secretary of the North Carolina Department of Health and Human Services. Secretary Cohen is, as you know, seeking a temporary restraining order and a preliminary injunction temporarily barring races and similar events at Ace Speedway, which is in Alamance County. I want to emphasize at the outset, and I cannot emphasize this enough, that Governor Cooper and Secretary Cohen are acutely aware of and sensitive to the economic and personal hardships imposed on businesses like Ace Speedway and their employees by the orders issued in response to the COVID-19 pandemic, closing or restricting the operation of those businesses. The Governor and Secretary Cohen are also sensitive and sympathetic to the impact on the public of restricting the operations of businesses like Ace Speedway that have been long-standing fixtures in their community and meeting places for members of the community. For these reasons, Governor Cooper and Secretary Cohen are anxious to reopen and lift restrictions on businesses and activities as soon as public health circumstances safely allow them to do so. That is why Governor Cooper, Secretary Cohen, and their senior advisors are in regular contact with businesses, industry representatives, including a number of racetracks, and workers to develop plans and protocols that allow for safe reopening of businesses. But unfortunately, for certain businesses, including Ace Speedway, The continuing risk posed by the COVID-19 pandemic dictates that public health restrictions on their operations remain in place. At present, more than 110,000 Americans, more than 1,000 North Carolinians, and at least 23 residents of Alamance County have died from COVID-19. As Mr. McKinney's letter to the chair of the county commission and to the sheriff indicated, which is Exhibit C to the complaint, Burlington recently was reported to have the highest rate in the growth in COVID-19 deaths in the country. And Secretary Cohen's abatement order, which is Exhibit D to the complaint, states that Alamance County is one of the counties in North Carolina with, and I quote, the most troubling data indicative of COVID-19 spread. That's paragraph 1.8 of the abatement order. This troubling data and the uniquely high risk of COVID-19 transmission posed by large events such as the recent races at Ace Speedway is why Secretary Cohen determined in her abatement order that the continued operation of Ace Speedway is, and I quote, an immediate threat to human life and again I quote, an immediate threat of serious adverse health effects if no immediate action is taken. This case, in which Secretary Cohen, as I said before, seeks a TRO and a preliminary injunction temporarily barring races and similar events, is that immediate action. This action is necessary because Ace Speedway has refused to share in other North Carolinian sacrifices to preserve our collective public health. Ace Speedway has repeatedly and flagrantly violated the governor's executive order banning gatherings of more than 25 persons at large outdoor sporting events. Those repeated flagrant violations have placed spectators, residents of Alamance County, and all North Carolinians at grave risk. Now, before you at the moment is the Secretary's motion for a temporary restraining order and a preliminary injunction. As you know, the criteria for awarding a TRO and a preliminary injunction is that the party seeking the TRO and injunction must have a likelihood of success on the merits. There must be a risk of irreparable harm if the preliminary relief is not awarded, and then the public interest must weigh in favor of awarding the relief sought. So as to the first question, likelihood of success on the merits, the Secretary issued a valid abatement order pursuant to North Carolina General Statute 130A-20A. That order, which is Exhibit D to the complaint, as I mentioned, recites the risks, facts surrounding the races, and the need for the abatement of an immediate hazard. It complies with all terms of the statute. Second, there's also no dispute that the defendants violated the abatement order. The abatement order had three specific provisions that must be satisfied. One, it required that ACE cancel races at the Speedway and similar large events while the executive order remains in effect. ACE has not done so. Second, in fact, on their website, which I checked late last night, it still lists a race scheduled for June 13th, this Saturday, as well as one for the following Friday. Second, the abatement order required that ACE provide public notice that it was canceling the race, the future events and races at its Speedway while the executive order remains in effect. That public notice requirement was put in place and carefully designed to ensure that people did not come out to the track, wait in line, and pose a risk of transmission of COVID-19. Third, the abatement order required that NCDHHS, that ACE Speedway provide a notice to NCDHHS that it has provided this public notice. ACE Speedway has not provided public notice, and it has not provided any confirmation to NCDHHS of that notice. Accordingly, it's established that there is a likelihood of success on the merits. There was a valid abatement order, and the terms of the abatement order were violated. So turning to the irreparable harm, the abatement order, which I will focus on, lays out serious and immediate risk to public health if these races continue. I'm going to go through some of the specific risks posed by operating these races and the specific references in the abatement order to those risks. So one, the abatement order explains that large gatherings, regardless of whether they're indoor or outdoor, pose a higher risk of COVID-19 transmission than small gatherings. There's two reasons for this. One, at a large gathering like the races that occurred at the Speedway recently that had between 2,000 and 4,000 people, there's more likely to be somebody there who has COVID-19. Second, if there's a large number of people at an event and somebody has COVID-19, the person who is infected with COVID-19 has the potential to spread it to more individuals. Accordingly, large events like the recent races at the Speedway pose a unique risk to public health. There's been studies showing that at large festive gatherings, including outdoor gatherings, that there is more spread of COVID-19 relative to small gatherings. So the percentage of people at the gathering that end up having COVID-19 is greater. And the people who are come down with COVID-19 exhibit more symptoms relative to people who contract COVID-19 at smaller gatherings. So that's the first reason. It's a large gathering where lots of people are attending. The second reason is that people at the Speedway are staying in close proximity for an extended period of time. The abatement order, and this is paragraph 3.2, notes that when people stay in close proximity for an extended period of time, and it indicates sitting or standing next to each other for more than 10 or 20 minutes, there is an increased likelihood of COVID-19 transmission. The photographs that are in Exhibit B to the complaint show hundreds, if not thousands, of spectators standing closely together in a line waiting to get into the Speedway, sitting next to each other in the stands. That is a high risk of COVID transmission. The races last for several hours, and so this period of time when the transmission can occur is extended. So first thing, large gathering. Second thing, extended period of time in close personal proximity. The third reason is that COVID-19 transmission is uniquely likely to occur in settings where people have increased respiratory effort, like cheering and yelling. That's referenced in paragraph 3.4 of the abatement order. Again, if you've ever been to a race, it's loud and you have to yell to talk to people that are near you. If you're cheering for a particular car, you're going to be yelling and cheering. When that happens, you expel respiratory droplets, and those respiratory droplets are the mechanism through which COVID-19 is transmitted. So that's the third reason that there's a high risk of transmission at the Speedway. The fourth reason is that people are congregating in the grandstands and restrooms and concession lines, concourses, and waiting to get into the Speedway and sharing facilities. And under paragraph 3.4 of the abatement order, again, that poses an increased risk of spread of COVID-19. So you have these four features of the races at a Speedway that increase the risk, meaning that it poses a unique risk of spread of COVID-19. Then you couple that with the fact, as I mentioned earlier, that Alamance County has among the most troubling data indicative of COVID-19 spread, and that's paragraph 1.8 of the abatement order. And that, as I mentioned in Mr. McKinney's letter noted, that it has the highest growth rate, or recently had the highest growth rate of COVID-19 deaths in the country in Burlington. So, because of all this, there is a risk of irreparable harm if the races occur this Saturday. There is the high risk of transmission and more COVID-19 morbidity and mortality if the races are allowed to go on. For the same reason, the final consideration with regard to entering a preliminary injunctive release or temporary restraining order is that the public interest weighs in favor of doing so. In this case, as I said, there is a significant public health risk. It's been recognized by every court that has considered the issue. It's also been recognized by every court that these type of mass gathering restrictions serve that public health risk. And so therefore the public interest lies strongly in favor of the governor and the secretary in ensuring that COVID-19 spread does not occur through these large events at the raceway. So that is the basis for awarding injunctive relief. I'm happy to answer any questions you might have.
All right, thank you. I don't think I have any at the moment. Do either of you wish to be heard at all?
Yes, sir. Thank you.
All right. Thank you, Mr. Casper.
Thank you, sir.
Mr. Kitchen?
Thank you, Your Honor. I have a declaration from Robert Turner I'd like to hand out.
Yes, sir.
And I'll apologize to the court for not having a brief. We only found out about the case yesterday when I got an email attaching the complaint, and we have simply not had time to prepare something. I usually like to have be better prepared and be able to present something to the court. I do want to first go over some of the things in the declaration. I want to make the court aware of it, and then go into the more legal part of the argument. First of all, in the complaint, it indicates that Robert Turner and Jason Turner are owners of Ace Speedway Limited. As Mr. Longus has indicated, they are not the owners. They do not have any ownership interest in that company, and it's my understanding that Ace Speedway Racing Limited is a prior owner of the track or operator, one or the other, but that was several years ago. I do want to say that by appearing today with the defendants I'm representing are not waiving personal jurisdiction. They have not been served at this time, either by an order of the order of abatement, nor have they been served a copy of process. One of the things that counsel has mentioned is about the dangers of having the race. Prior to having a race at Ace Speedway, Mr. Robert Turner met with the sheriff, the county commissioner, and the public health director, was given specific control measures to be used. Those control measures have been used. There are pictures have been put out. I don't remember them having any in their documentation. We'll have some later on if we go to a second hearing. But some of those include things like taking temperatures. They check to see there's a sign up where people can sign up. They know that doesn't work very well, so they take tag numbers so that if someone tests positive for COVID, that they can be traced and whoever was exposed can be notified. Also, Your Honor, to my knowledge, this is the only speedway in North Carolina which the state is going after. And I'll speak more to that. Last weekend, there were between 9 and 12 races across North Carolina, had fans present. And on Memorial Day weekend, there was a race at Charlotte Motor Speedway, which had over 400 people participating in it as drivers and crews. And in addition, the luxury boxes that are at the Speedway, people were allowed to gather in there to watch the race. Those were indoors. They decided that as part of it, they did not allow anyone to watch it from outdoors, which seems to be odd to me, considering the greater risk is for people to be indoors next to one another rather than being outdoors in the sunlight and the air and so forth. Now, to the more technical legal part of this trial. As I said, my clients have never been served with an order of abatement. In addition to that, the order of abatement does not name them. The order of abatement is addressed to Ace Speedway Racing Limited, a North Carolina corporation, as to enforce an order to get an injunction. I presume the state, although they didn't say what basis they had for being able to do it other than the rule, is moving under GS 138-18. I may approach, Your Honor.
Yes, sir.
This particular statute permits the secretary to give an injunction anytime, in particular here, when an order issued under the chapter is violated. So as a condition precedent to any action in court or any injunction being issued, there must first be an order. The order needs to be served so people will have notice of it. And third, there must be an actual violation. Counsel has talked about the violation. I won't talk about it. As I mentioned, clients are not named, they've not been served, and the third thing is, have they violated it? At this point, Your Honor, I would submit there has been no violation of the order by my clients, with the exception of what they can constitutionally do. One section of the order, which was discussed, talks about how they were required by the order to give notice to the public and then report back that the notice had been given. Our position is that violates the First Amendment to the Constitution. Let me approach, Your Honor.
Yes, sir. No problem.
This case out of the Middle District of North Carolina, 2011 case. On page 5 of the opinion, I've marked some areas. It talks about what the First Amendment covers. The First Amendment generally includes the right to refuse to engage in speech compelled by the government. In other words, if the government wants something said, the government has every right to go and say it itself. It cannot tell an individual, you go tell them what we want you to tell them. That kind of speech, mandating speech that would not otherwise be made, implicates First Amendment. It's considered content-based regulation, subject to strict scrutiny, and is presumptively invalid. I will submit to the court that the order, which is in section 2B, where it says that a Speedway shall notify the public by 5 p.m. on Tuesday and so forth, is such a compelled speech which is invalid under the First Amendment. Obviously, my clients would not be given that notice were they not being compelled to do so by the state. And since it's subject to strict scrutiny, the state has an easy way around that, and it's simply that the state could give the notice itself. They did not have to have a Speedway give the notice, and as such, it's a violation of the First Amendment. Now, they also said that there's a violation because a Speedway was ordered to immediately be closed and not hold any further races. They have held no further races since this order went into effect. So I submit to the court there has been no violation. Under the general statutes, 130A:18, you can't get an injunction until 1, you have the order, 2, the order is going to be served, 3, there's a violation. Never named my plaintiffs or my defendants. They never served it on my defendants. And third, there's been no violation yet. And without a violation, the court lacks subject matter jurisdiction. It's a condition precedent to having the ability to issue the injunction. Second thing, Your Honor, I'd like to address, this particular order of abatement is essentially trying to enforce Executive Order 141, which is the current executive order in effect by the governor that prohibits mass gatherings of more than 25 people outdoors. And if you read the complaint, it's all the way through it. They talk about the executive order, what the executive order does. The injunction they ask for, the permanent injunction, only lasts as long as the executive order is in effect. It is, in essence, trying to enforce an executive order. There are 2 problems with that, and I'll address 2 problems in turn. Let me approach you.
Sir.
The first is our position that Executive Order 141 is unconstitutional. On page 11 of State v. Harris, which I've given to the court, the North Carolina Supreme Court addresses the power of the state, not the power of the governor, nor the power of the Secretary of Health and Human Resources as to what they can do. This is the power of the state. Neither the state nor the legislature has the power to keep a citizen from pursuing an ordinary vocation on their own property with their own means. And what it says below that, which is very important, I believe, Your Honor, it says, while many of the rights of man are, as declared in the Constitution, contemplate adjustment to social necessities, some of them are not so yielding. Among them is the right to earn a living, which must be regarded as inalienable. Very simply, this order is attempting to keep my clients from earning a living. They're trying to shut down the raceway. Now they say, oh, we have a plan. You can just submit a plan and that plan will be fine, we can approve it, and you can go back to racing. Well, as a practical matter, Your Honor, that's simply not the case. The very first thing that they require, at a minimum require, is that a speedway adhere to mass gathering restrictions of 10 spectators inside and 25 spectators outside. You can't run a race like that. It just doesn't happen. You're talking about 2 to 3 cars and no one else in the stands. A speedway sets seats over 5,000 people. So you've got 5,000 seats out there and you can only have 25 people show up. That is arbitrary and capricious. There's absolutely no rational basis for something like that. But we never get to the rational basis. Why don't we get to the rational basis? Because the state does not have the police power to shut them down, not just as a business. Could the state have restrictions on what they could do that were reasonable and allow them to operate? Yes. Just like the health director here gave them restrictions, said, here's your control measures. You need to comply with these control measures. They've done that. If the state gives reasonable control measures, they will abide by those reasonable control measures. What they can't do is say, we'll only have 25 people in the stands, or 25 people altogether. It simply is not reasonable. It shuts them down. They in essence, have been ordered to close and cannot make a living. And for that reason, Your Honor, this is, I did not say it, but this is the fruits of your labor clause, which is Article 1, Section 1 of the North Carolina Constitution, and it violates that provision. The second thing, Your Honor, on that particular issue, I may approach you, Your Honor.
Yes, sir.
I'll hand up News v. Barrett. On the third page of News v. Barrett, I've highlighted the appropriate area. Essentially, what this case stands for says, if there's a remedy given by statute and it's intended to be exclusive, in other words, it doesn't say anything else in it, then you must use that particular remedy. The statute regarding Executive Order 141 has a particular remedy. And let me hand that up for the court as well. This is the particular statute, 166A 19.30, which gives the governor the authority, or it is the act that the governor has acted on in issuing his executive orders. If you look at page 3, it prescribes the violation. The violation of his executive order is a Class 2 misdemeanor. That's what the General Assembly said. If somebody violates your order, you can have them arrested. What has the state done? Well, they said, Sheriff, this person is violating his executive order and we want him arrested. Send a letters attached to the complaint. The sheriff refused to arrest him. So what have they done? Well, they decided they were going to go around the statute and bring this action in which an order of abatement is issued instead of an arrest warrant or criminal summons, or however they wanted to pursue with the criminal charges. I will submit to the court this is improper and that the state has unclean hands in trying to ask that a temporary restraining order be issued. The third issue, Your Honor, involves equal protection. And I submit to the court that in bringing this action, the state has engaged in selective enforcement of its statutes. And I'd like to hand up Grace Baptist Church of Oxford versus the City of Oxford. In this particular case, the Supreme Court considered an ordinance and stated that an ordinance may be valid on its face yet deny equal protection because it's enforced in a discriminatory manner. That's what we have here. What they have done is they have decided that they're going to go after a speedway. Why did they do that? Well, it's in the complaint. Robert Turner spoke out against the governor. He said he didn't agree with the orders that had been given. And so what did they do? They sent a letter to the sheriff. I submit to the court, this is an unusual proceeding. I am unaware of any other cases. There may be some, but I'm not aware of them, where the governor has taken it upon himself to have his council send a letter to a local sheriff saying, we want somebody arrested for violating the sheriff's orders. The governor's orders. In this case, they have decided that Ace Speedway is going to be that one example they're going to make because Mr. Turner spoke out. In doing so, they've come after Ace Speedway. As in the declaration, there's 9, 10, 11, 12 other tracks out there racing. We don't see orders being, imminent hazard orders being sent out based on these other tracks racing. We don't see letters coming from the governor's office saying, oh, Sheriff, you need to go arrest those people. And more importantly, when Charlotte Motor Speedway, which was race was televised for all the world to see, had hundreds of people there, clearly violated his executive order, 141, it had more than 25 people outdoors. Did the governor do anything about that? No, of course not. This is a big event. It was on television. But Ace Speedway in Alamance County, they feel they can come shut it down. Now, if the Ace Speedway was being televised, had rich people owned it, would we have the same result? I suspect we would not have the same result. And I would submit to the court, that is selective enforcement. If it's wrong to have races, all races have to be shut down. You can't just pick on one in Alamance County. For those reasons, Your Honor, one, that I don't believe there's a likelihood of success on the merits. For one thing, there's been no violation. That's the big thing. There's been no violation of the order. My defendants were not named in the order. Now, if the court wants to issue an order against Ace Speedway Racing Limited, I don't represent them. That's who the order was directed to. It wasn't directed to my clients. But in order to violate an order, first, what's basic in the law is you've got to be served with the order. You've got to be given legal notice of that order. You can't just haul somebody into court because I've issued an order. Oh, I'm not going to serve it on you, but if you violate it, then I'm a suit. There's been no service, there's been no violation. Therefore, Your Honor, under the statute, there can be no injunction. In addition, as far as irreparable harm is concerned, Your Honor, Ace Speedway, the races there are complying with the directions from the local public health director. I would submit that the state simply is not able to show irreparable harm unless they want to take on the local health director and say he was wrong about what he did, and they haven't made that allegation. Ace Speedway, the people there are trying to comply. They want to have a safe racing environment. Granted, there are pictures of people in the stands sitting next to each other. As far as I know, those are families. I don't know how many people came together. We have no way of knowing that. As far as I know, there have been no confirmed cases of any spread of COVID-19 from Ace Speedway. They say they've been having races. Well, where's all the people getting infected? Why don't we know about that? They have the records of who was there. they haven't, you know, no one's come forward and said, hey, we found out somebody had COVID-19. Who was sitting near them, or who was there? Who should we notify? We've got all those records. For those reasons, Your Honor, I would submit that a temporary restraining order should not issue, that it would be improper, and beyond that, it would be unconstitutional. Thank you, Your Honor.
And let me just clarify, you're speaking as to just the two Turners, those are your clients?
And
After 5?
After 5 Events LLC, those are my 3 clients.
So this declaration you've handed up, I will note it's unsworn, but this, I guess that's why it's called a declaration, not an affidavit.
This has been, yes, Your Honor, this has
And I
been
understand
given,
this all happened quickly, I understand that.
and this has been given pursuant to the Chief Justice's order of April 2nd, which allows for declarations in lieu of affidavits.
Good, that's a good point. But so it's a little nebulous. It says that they are not owners or have an ownership interest in ACE or the Green Street Partnership, but they are members of After 5 Events. Is that who runs the Speedway?
Yes, Your Honor.
Okay, so they're the ones who actually are putting the events on?
Yes, Your Honor.
Okay, just wanted to clarify. That's sort of
Yeah,
what I read between the lines.
Yes, the complaint alleges they own this Ace Speedway Racing Limited, and that Ace Speedway Racing Limited is part of the operations along with After 5. Simply isn't true. That's not correct. After 5 Events Limited, or LLC, is the legal entity which runs the races. And I didn't say it, but I will say it now. Obviously, they, as members of an LLC, Jason Turner and Robert Turner are not liable for the acts of the LLC. And we will be making a motion to dismiss at appropriate time and get them out of it, because that's not the legal entity which runs the race is After 5 Events.
All right, thank you, Mr.
Thank you.
Kitchen. I'm going to let both sides say anything they need to, so I'm going to let you all respond. I'll certainly let you respond back. I'd rather have more information than less. Mr. Casper, do you want to respond?
Yes, sir. I appreciate the opportunity. May I approach?
Yes, sir.
This is a certification I just give to you. It's of the certification of notice of intent to seek a temporary restraining order. So this is addressing the issue of service, of notice, and I want to address that because I think that's a very important question. And so I want to first of all say the abatement order statute does not require that the abatement order be served on any particular party. Nonetheless, we have been committed and working as diligently and hard as possible to try to notify and serve the abatement order on anybody who potentially operates the Speedway. So to that end, on Monday when we were issuing the abatement order, we sent the abatement order to every email address we were aware of that was potentially applicable to anybody associated with the Speedway. We also emailed and served the abatement order on Mr. Longuest, who is so the Speedway, the land that the Speedway is on is owned by the 1804 to 1814 limited partnership that is a defendant in the case. So we named them as a defendant because it's their property where the imminent public health hazard is occurring. We emailed and served the order on that entity and the registered agent. We placed the abatement order in the Speedway's mailbox. We emailed the abatement order to the point of contact listed on the Speedway's website. DHHS issued a press release that day announcing the abatement order, and that abatement order and that press release was covered by numerous media outlets. There was an article in the News and Observer on June 9th. We know this notice was effective. How do we know this notice was effective? Because Mr. Kitchen emailed Ms. Corbett on Tuesday saying he represented a Speedway. If you look at Exhibit A in the document I provided to you, on page 1 of Exhibit A, it says, Ms. Corbett, I wanted to let you know that I am representing the owners of A Speedway. Please give me a call at your convenience. When Mrs. Corbett received that email, she immediately contacted me. I soon thereafter gave Mr. Kitchen a call. During that call, he said that he was contemplating bringing contested case action in an administrative proceeding to challenge the abatement order. I indicated to him that the department, if his clients did not comply with the abatement order, we would be bringing this action in Superior Court the following day. I also made him aware that we would be seeking a preliminary or temporary restraining order hearing on Thursday at this time, so he would know to be aware. So Mr. Kitchen reached out to Ms. Corbett saying that he represented Ace Speedway, which means Ace Speedway was aware that the abatement order existed. As to the service of the complaint, I will note that during our call, I asked Mr. Kitchen if he would identify which individuals or entity were his client and which entity operated the racetrack, so we could name the proper defendants in the complaint. And I also asked if he would be willing to accept service on his client's behalf. If you look at Exhibit B in the abatement order, or in the certificate I just provided to you, if you look at page 2, Mr. Kitchen emailed me and says, I have talked with my client and have been instructed that I cannot release the name of the client, nor can I accept service on its behalf. Accordingly, we were not given information to determine exactly who operated the Speedway. We knew that it was, the reason we named Ace Speedway Limited, Racing Limited as a party was because they had the same process service agent, Mr. Longus, as the entity that owned the real estate on which the Speedway is located, and they had the same president, which is this gentleman in Pennsylvania. And so we felt like because the property was owned by those two entities and it had the name of the Speedway, we needed to include them in the action. We also named After Five, the After Five entity, because the two Turner gentlemen were the members listed on the Secretary of State's website in that entity, and we also sought to effect service. In order to provide notice of this hearing and try to effect service, I emailed Mr. Kitchen. After having already told him about the hearing, I emailed him a copy of the complaint as well as the summonses and the other documents included with the complaint. I emailed him a notice of hearing and an amended notice of hearing because of a couple errors in it. We had our process server serve the complaint on the registered agent, Mr. Longus, who received notice for the entity that owns the property, which is 1804 to 1814 according to Alamance County tax records. And we also served Ace Speedway Racing Limited. We put the complaint in the mailbox of Ace Speedway, which is the principal place of business listed for Ace After Five events, and we tried to effect service on the individuals as well. I also emailed a copy of the complaint and associated materials to the contact address on Ace Speedway's website. That email address is jason@acespeedway.net, which I think, given that Jason Turner operates the Speedway according to Mr. Kitchen's representations, provides some indication that would be an email address that is associated with him. That email did not bounce back. All this being said, we went to significant lengths to ensure that they were notified of the order and that they were notified of this hearing. And as Mr. Kitchen's participation indicates, they are on notice of this hearing.
Yeah, and it's worth, I was doing some research on Rule 65 this morning. And of course, this is just the TRO hearing. You have not gotten summonses, you've not gotten actual return of service. And if I'm remembering, Rule 65 simply just requires you to attempt to give notice. And at this stage, and clearly at least two lawyers are here who received notice through their clients.
Yeah, so this could be an ex parte proceeding.
And I was going to say a lot of these are ex parte proceedings, and I appreciate the fact that y'all did not seek that route because I wouldn't have allowed that.
So yeah, we have tried with all of our resources to effect service and notice, and we have been as successful as we could in the circumstances, particularly given Mr. Kitchen's decision not to disclose his client's name.
Well, it does say, Mr. Kitchen, it looks that you emailed Ms. Corbett on June 9th at 4:16 p.m. and said, Ms. Corbett, I wanted to let you know that I am representing the owners of Ace Speedway.
And I do, Your Honor.
Well, you do. I mean, that's not what Mr. Turner's declaration says. He says he's not an owner.
He's not an owner of Ace Speedway Racing Limited or Green Street Associates Limited partnership. My client informs me he owns it, and that as far as the nominal legal owner, I'm not entirely clear of that because I haven't got involved. My understanding is there is a fairly complicated financing that had taken place when he purchased the Speedway, but that Green Street Associates nor Ace Speedway Racing Limited really have anything to do with it. I think it's just financing.
Just wanted to clarify that. That's what's in this exhibit that was just handed up with the declaration of service. Go ahead, Mr. Castro.
I would just add to that I think that including 1804 to 1814 limited partnership is important because they own the property, and that is the property where the public health, the immediate public health hazard is occurring. And so that obligation to abate the public health hazard runs with the property, as well as with the operators on the land. So Mr. Kitchen raised several arguments as to, in addition to sort of lack of notice, several arguments as to why the abatement order is not enforceable as to his clients. First of all, he indicated that there's been no violation of the abatement order, and he said that with the notice requirement in the abatement order, which there's no dispute, they have not provided notice. And there's also no dispute that they did not provide any confirmation to NCDHHS of their provision of that notice. So assuming those two conditions are valid, they have been violated. And he says, and his position is that those two conditions violate the First Amendment because they amount to requiring compelled speech. That is not the case. So it's well established that the government can require private parties to disclose information to prevent, in the course of commercial transactions, to prevent confusion or deception. Here, the Ace Speedway's website advertises races occurring at the Speedway on June 13th and June 19th. Those races violate the law as set forth in the executive order. Requiring a Speedway to notify the public to prevent confusion as to whether those races can go forward is a reasonable restriction. That is, if you look at the case Zotterer from the Supreme Court, 471 U.S. 626. So I don't have a copy for you right now, and I'm happy to provide it subsequently. The Supreme Court says, that requiring disclosure of truthful or purely factual information to prevent confusion or deception complies with the First Amendment and is subject to rational basis review. Here, this would be purely factual information. They would be saying that we are not holding races at the Speedway on June 13th and June 19th. In addition, there's a well-established body of case law, and I would refer the court to the decision Handsome Brook Farm. It's a Fourth Circuit case from 2017. Citation is 700 Federal Appendix 251. And again, I can provide you with that decision. And Handsome Brook Farm applies the Zotterer decision, and it says, disclosure requirements aimed, I'm quoting, disclosure requirements aimed at misleading commercial speech need only survive rational basis scrutiny by being reasonably related to the state's interest in preventing deception of consumers. So, as I said earlier, the current statement on the website that there will be races on June 13th and June 19th contradicts both the abatement order and the executive order. It could be deceptive to consumers, and it will also undermine public interest. If lots of attendees show up at the raceway on Saturday evening and they line up trying to get into the raceway, they will be posing a significant risk of spreading COVID-19. One of the images in Exhibit B is of people lining up outside the raceway, and you can see that they're in close proximity. So this notice requirement to prevent confusion and deception, to ensure that people do not go there thinking that there will be a race and then have a risk of a mass gathering that causes spread, is an interest that is served by that requirement, and therefore, because it's only subject to rational basis review, the compelled disclosure requirement that they notify the public if races are canceled complies with the First Amendment. Accordingly, because those two provisions comply with the First Amendment, they are valid provisions, and there is no dispute that those provisions have been violated. Second, Mr. Kitchen stated that that his client's activities fall within the exemption for First Amendment activities in the Executive Order 141. I would initially like to emphasize, just a second. That's not, whether Executive Order 141, whether they fall in the exemption to 141 is not decisive in this case. The Secretary is proceeding under her abatement order, and that abatement order is valid. And so therefore, if they're in violation of the abatement order, the Secretary may obtain injunctive relief. Even so, I want to be clear that the Speedway's mass gatherings do not fall within the exception to Executive Order 141 for First Amendment activities. As detailed in the brief which I handed up at the beginning of the hearing, that exemption encompasses only First Amendment conduct to the extent doing so is necessary to comply with the First Amendment. So this type of First Amendment speech conduct that he's referencing. Accordingly, the race, as long as the enforcing the order against the Speedway complies with the First Amendment, then it does not fall within the exemption to the executive order, and that's laid out in the brief. Here, there is no question that enforcing the executive order and the abatement order complies with the First Amendment. I want to quote to you, actually let me hand this up. May I quote, Your Honor?
Yes, sir.
So this is a recent opinion from Chief Justice Roberts in the Supreme Court in the case South Bay United Pentecostal Church versus Newsom. That case involved a challenge by a church in California to numerical limits on in-person attendance at churches under an executive order promulgated by the governor of California in response to the COVID-19 pandemic. The Supreme Court refused to temporarily enjoin that order as applied to the limitation on the number of in-person attendees. I'd like to read from Justice Roberts' opinion. He says, the precise question of when restrictions on particular social activities should be lifted during the pandemic is a dynamic and fact-intensive matter subject to reasonable disagreement. Our Constitution principally entrusts the safety and health of the people to the politically accountable officials of the states to guard and protect. He cites the Jacobson case, which is from 1905. You may have read that one. It's where there was a smallpox outbreak and the government compelled people to be vaccinated, and the Supreme Court said, even though that was an intrusion on constitutional liberty interests, that it was nonetheless justified as a reasonable response to the smallpox outbreak. Justice Roberts continues, when those officials undertake to act in areas fraught with medical and scientific uncertainties, their latitude must be especially broad. And he further says, the judiciary, he advises that the judiciary should be especially, I'm paraphrasing here, should be reticent to intervene when the public health officials and the governor make determinations about how best to deal with a public health emergency like the COVID-19 pandemic. That reasoning applies in spades in this situation. This is a fast evolving situation in which Governor Cooper and Secretary Cohen have made rapidly evolving decisions based on ever-changing data to try to best protect the public health. This is when the judiciary's deference to these executive branches is at its apex. And in that context, the Supreme Court said the First Amendment rights to free exercise of religion needed to give way to the state's need to prevent the public health emergency. I would argue that same reasoning applies in this context. Indeed, just this week, the Eastern District of North Carolina, an opinion by Judge Flanagan in the Tallywacker matter, and I'm going to hand that up right now. May I approach, Your Honor?
Yes, sir. Thank you.
Judge Flanagan, there was a number of entertainment establishments that challenged the executive order restriction on mass gatherings and the closure of entertainment facilities. So the same provisions that a Speedway is subject to. And Judge Flanagan ruled that those restrictions did not violate the First Amendment. In the case, she relied heavily on Justice Roberts' reasoning in the South Bay matter, and she explained that in this circumstance, the First Amendment was satisfied because there was a real and substantial, the mass gathering limitation, which limits the number of people at events, and as I said earlier, the more people at an event, the greater the risk of spread of COVID-19 is a reasonable and appropriate way to address this public health emergency. I would further note that based upon my research, every case that I have found that involves a First Amendment claim premised on freedom of speech and assembly, unrelated to religious speech rights, the court has ruled in favor of the government, saying that the mass gathering restrictions are appropriate and comply with the First Amendment. There's also, it was raised whether they, Mr. Kitchen raised the question of whether the executive order infringed on the right, the fruits of labor clause in the North Carolina Constitution. Earlier this week, there's Judge Gale has been appointed to oversee a number of challenges to the executive order brought by various business groups, seeking under, among other provisions, the fruits of the labor clause. Judge Gale declined to enter in a temporary restraining order barring enforcement of the executive order against those businesses. In that order, he quoted language from previous Supreme Court opinions saying that fruits of the labor clause challenges in this context are subject to rational basis review. As you are aware, rational basis review is very deferential to decisions of elected officials like Governor Cooper and Secretary Cohen. And as long as a challenge restriction is reasonably related to a legitimate public objective, those restrictions are upheld. Here, every court to have considered the issue has concluded that public officials have a substantial interest in ameliorating the effects of the public health emergency posed by COVID-19. Courts have also consistently held that mass gathering restrictions, like the one that the governor seeks, the secretary seeks to enforce against a Speedway here, serve that legitimate interest, and so therefore, under rational basis review, these restrictions are lawful under the fruits of the labor clause. I would further note that Mr. Kitchen represented that the executive order shut down a Speedway. That is not accurate. The executive order restricted its operations to 25 spectators. Accordingly, a Speedway could operate with 25 spectators. And in fact, a Speedway, I understand, had discussions with DHHS about doing that. The operators of a Speedway do not want to have their operations restricted in that manner, but it's an objection to that provision, did not shut down their business entirely. I'd also like to address the selective enforcement argument that Mr. Kitchen raised. He mentioned several times that stated several times that the Charlotte Speedway operated in violation of Executive Order 141. That is not accurate. The Charlotte Motor Speedway was in close consultation with DHHS throughout the process of planning those races. Executive Order 141 provides that for large venues like Charlotte Motor Speedway and a Speedway, there can be no more than 10 people in a single confined indoor space or 25 people in a single confined outdoor space. The separate suites at the Speedway would be separate indoor spaces. My understanding is that their race was operated fully in accordance with the executive order, and that DHHS worked closely with them to ensure that that was the case. He also, the declaration referenced that other races might have occurred in North Carolina that do not comply with the order, and this point was made to suggest that the governor and the secretary are singling out a Speedway. That is not accurate. So my understanding from talking with DHHS officials is that they have reached out to 6 large Speedways since these orders have been in place to talk about operations and complying with executive order. 5 of those speedways have participated in communications. All 5 of those speedways are operating in compliance with the executive order. They are doing it in different ways. So some speedways have no spectators. They're just allowing the competitors to race. Other speedways have 25 or fewer spectators. And then some other speedways are having spectators stay in their cars. So there are a number of speedways that have been in contact with DHHS have been operating in compliance with the order. DHHS has only received one other complaint about a speedway operating outside of compliance with the order, and that was within the last week. And my understanding is that local health officials have reached out to that speedway about its violation, so they are seeking to enforce the order as against local speedways. If DHHS has not been informed the speedway is in violation, then there's no way for it to go out and seek compliance. But when it has been informed, it has sought to ensure compliance. In this case, the operators of a speedway have been open and flagrant about their intent to violate the executive order, which made it easily put on DHHS's radar, and that is why this enforcement action has been brought. And they have engaged in those violations repeatedly after they've been informed that they violate the executive order. Mr. Kitchen also said that there's an exclusive remedy issue here, which is that the executive order 141 has a provision requiring, saying that it's a class 2 misdemeanor for violating the executive order. That is correct. However, local law enforcement has declined to enforce the order against the speedway. That is why Secretary Cohen has elected to issue the abatement order to ensure that there is enforcement. The abatement order is an independent basis, statutory basis to abate the public health hazard. In this case, the statute expressly authorizes injunctive relief against an entity that violates an abatement order. And that is what the Secretary is pursuing here. So this action is in compliance with the general statutes. As to selective enforcement, I'd also just like to add that any selective enforcement claim under the Equal Protection Clause requires that there be an invidious purpose. It's not just sufficient that there's been differential treatment, it has to be for an invidious purpose. And Mr. Kitchen has put forth no evidence that the Speedway that the Secretary's actions against the Speedway are motivated by any purpose other than trying to preserve public health. And that is a valid purpose and not an invidious purpose. Mr. Kitchen also suggested that the Speedway operators were targeted because they spoke out against the executive order, and that bringing an enforcement action against a vocal person who refuses to comply with an executive order is protected First Amendment activity. I would just say if that is the case, then no law would be enforceable, because any person who objected to a law could simply speak out against it, and therefore that speech would protect them from enforcement. That would render all of our criminal and civil laws unenforceable, and that can't be the correct rule under the Constitution. Finally, Mr. Kitchen suggested that the abatement order does not target the appropriate entities, and therefore it's not going to serve any purpose because it doesn't name the Turners. The abatement order is targeted at, and this is quoting from the abatement order, the Ace Speedway facility. And so it's what the Secretary is trying to do is stop the races and other large events that violate the executive order and her abatement order at that facility. Whoever's operating them, whoever owns the land, we are trying to stop those events in order to serve the public health. That is the objective here. We've gone through all these efforts to try to effect service, to provide notice. Our objective here is really stopping the events to preserve the public health. Mr. Kitchen also mentioned that there's been no confirmed cases of COVID-19 spread coming from the recent races at the Speedway. I would note that there's been 3 races. Each race has been reported to have more than 2,000 spectators. There's photographs which depict more than 25 spectators at the race. The line is well in excess of 25 people. We don't know if there has been any spread from the particular races. What we do know, what is in the abatement order, is that Alamance County has one of the most troubling sets of data regarding COVID-19 spread in the state right now. I think it's among the 8 most troubling counties in the state. We also know that Burlington, which is in Alamance County, had, as I mentioned earlier, the highest rate of growth in the death rate in COVID-19 in the country, which means there is troubling spread in Alamance County. And this order serves that objective. If you have any further questions, I'm happy to answer them.
I don't. I think you've hit the points that I was troubled by. Either anybody else wish to speak?
No, sir, Your Honor.
Mr. Kitchen, I'm going to give you the last word here.
Thank you, Your Honor. I do want to comment on a few things that the council has put forward. First of all, as far as the Supreme Court's decision in South Bay United Pentecostal Church, I just note that this is not the Supreme Court's decision. The Supreme Court did not put out a decision. What is being quoted is the concurring opinion of the Chief Justice. The court itself did not state anything. The Chief Justice decided he would put out an opinion as to his position, which is only one justice on the Supreme Court. It's interesting it's his position, but that's just simply his position. The second thing, counsel went to some length to explain why my argument on First Amendment grounds as far as the gathering was not sound. Well, part of that is I did not make that argument. That is not our position for purposes of this hearing. Now, later on, will we look at that? We probably will, because they've spent some time indicating there's an argument to be made there, but at this point, I'm not making that for this hearing. As far as the First Amendment goes, it's relevant in two respects. One is the compelled speech. We would submit they are incorrect on the rational basis, because those cases go to when consumers are being cheated or being deceived. That is not the case here. This is the case where the state is trying to compel an owner of a racetrack to give notice that he does not want to give. That is strict scrutiny, and it fails. They also cite the Tallywhacker case for First Amendment purposes, which I find very interesting. I agreed with the Tallywhacker case. This is strippers, and they were going around and said they had a First Amendment right to violate Executive Order 141. I agree they didn't have that right. The court was absolutely correct in that decision. The reason the court was absolutely correct is on your fruits of your labor, which is one of our arguments, businesses which constitute social evils are not included under the protection of Article 1, Section 1. And Tallywhacker, you got a bunch of strippers, they're not protected. I'm sorry, they're just not under our Constitution. So I think the court had it right. They didn't have a First Amendment case. They don't have a fruits of your labor case. They're just out of luck. Judge Gale did deny a TRO seeking to enjoin the enforcement of Executive Order 141. That case has been set on for a preliminary injunction. Judge Gale has ordered additional briefing in it. It was not the case where the state is seeking a TRO. That's what we have here. The state is seeking an emergency order against a business in Alamance County, and they're saying, oh, it doesn't have to be shut down. You can go in and run. You don't have to have anybody paying money at the gate. Well, I'm sorry, Your Honor. This is a private speedway. It's not financed by the government. The Turners simply don't have the cash to go out and run races and give prizes and not have any money coming in. They will very quickly go into bankruptcy if that's the case. This is not one of those situations. It's also not it's not a dirt track where people just get together on Friday night and have fun. This is a real racetrack. And I will submit that there is no way the Charlotte Motor Speedway complied with the executive order. And I agree that the state did approve them racing, but the state is now using a different standard for a speedway. They also said in order to show selective enforcement, that we have to show more than just this one is being enforced. It's been enforced against one racetrack and no others. I will agree to that. Also will submit that they have in their own complaint, they made an issue about Mr. Turner speaking out against the government. And they indicate that's why apparently that's why they're going against him. They even said an argument. Oh, well, he's speaking out. Yeah, that is the First Amendment. That's what happens. If you speak out against the government and they say, oh, here's somebody speaking out, we're going to enforce against you and nobody else because everybody else is being quiet. Yeah, that is a First Amendment violation. That is what selective enforcement is. And he said, well, if that's the case, then you'll never be able to enforce a criminal law. That's not true. It is only when, and first of all, this isn't a criminal case. Obviously, they brought a civil case. But beyond that, just because someone speaks out doesn't mean you can't enforce the criminal laws. What it means is you can't enforce the criminal laws against this person and no one else. And we're submitting that is what's going on here. They can say all they want to about, oh, well, other speedways, we don't know about other speedways, and the ones we know about, they're not in violation. Well, there are in violation. We have a declaration which shows, and it's not contradicted by any other evidence presented before you today, that other races are going on and they are not enforcing. But getting back to the basic legal issue, you know, the abatement order was not directed toward my clients. They say, well, you knew about it. We sent out emails. Well, if everybody knew about it and they sent out all these emails, why didn't they name my clients to begin with? They should have either named them in the abatement order, or they could put out another abatement order as to them. They simply chose not to do so. They also say, well, since we sent emails to people, that's good enough. It's not. That's not legal service. There's no statute that says you can send an email and that constitutes Rule 4J service, or any kind of service. It's not Rule 4J nor Rule 5 unless you agree to it. In this case, there has been no service. There has been no violation of the order. I'm not going to repeat that argument, Your Honor, but I submit at this time that order has been complied with except for what they said, where they are compelling these defendants to make speech, and that is violation of the First Amendment. But more importantly, as I said earlier, it's a violation of A Speedway Racing Limited, who was named in the order, not my clients. For those reasons, Your Honor, emergency does not exist. We submit there's not a reasonable likelihood of success on the merits, and that at least at this time, a temporary restraining order should be denied. And obviously, they can put on a motion for a preliminary injunction, at which time we can present testimonial evidence as to what we believe is the case, and we can actually have time to brief it for the court's consideration. Thank you, Your Honor.
All right, thank you, Mr. Kitchen.
Your Honor, please, may I be heard?
You may, Mr. Longest.
For the record, my name is Frank Longest, Jr. I'm an attorney practicing in Burlington, Alamance County, North Carolina, and maybe unfortunately listed with the Secretary of State as the registered agent for A Speedway Racing Ltd. I do not know and haven't had an opportunity to check as to registration as an agent for 1804-1814 Green Street Associates Limited Partnership. Both of those entities have been former clients of our firm. A number of years ago, we formed those entities, and the operation of A Speedway at that time was under the auspices of A Speedway Racing Ltd., and it was owned primarily by an out-of-state resident, Abraham Weiskopf, who lives in Pennsylvania. Also, the land was put in the property title of 1804-1814 Green Street Associates Limited Partnership, and that limited partnership at that time, to my knowledge, leased the property to that A Speedway Racing Ltd. I'm here to appear today in a limited capacity to the court under Rule 1.2 of the State Bar Rules, and in particular with regard to the paragraphs relating to 1.2, Provision B, and then the subsection C that says a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances. Well, in candor with the court, I have not been employed to be here today, and so I'm here as the registered agent, having been served with papers as to the order of the matters been spoken to. Monday evening after hours, I got a call when I was at my office by myself. Somebody said he had some papers he wanted to deliver to our office. Could I open the door and unlock it had those papers, and I thought, to be candid, it was one of my partner's clients who was delivering some real estate papers that we were expecting. So I go and lock the door and receive in a plain white envelope this order that's been referred to today. In looking at the order, I noticed that it said it was specifically defined as applicable to Ace Speedway Racing Ltd. That any reference to Ace Speedway Racing referred to that particular entity. And of course, in checking my records, I realized that we haven't represented this entity in a number of years. Checking online did find that the Secretary of State still has it as an entity, although normally it would have administrative dissolution applied because it hadn't filed an annual report in a number of years, in particular 3, I think. So, unbeknownst to me, I should have resigned long ago and as a registered agent, but failed to do so, so therefore I'm here. But in checking the next morning and doing some calling, I found out that Ace Speedway Racing Limited has nothing to do with the racetrack's operation at this point in time, that my former client has no operations being conducted at the racetrack. We believe they still own the underlying land, but that is nebulous because I couldn't talk specifically to my client. I just got information from an administrative assistant there. Because as I've stated, my client is being suffered by the virus that's kind of running.
It's very,
Now,
very ironic.
So the situation would be that I received this order after hours on Monday evening. I did some checking on Monday morning and found out that Ace Speedway Racing Ltd. Has nothing to do with the operation of the racetrack. I immediately, around 12:40 Tuesday morning, emailed the Honorable Secretary, Mandy Cohen, and sent her a memo that Ace Speedway, referenced in her document, is not applicable to Ace Speedway Racing Ltd. Because it no longer operates the racing track or the facility. And I sent that to her because that was the only communications link I had. There was nothing on the envelope, there was nothing except for the order itself. So I sent that and never received a reply. Yesterday afternoon, late, I get another 2 envelopes delivered to my office, plain white envelopes. One of them says, Ace Speedway Racing Limited, and the other one says 1804-1814 Green Street Associates Limited Partnership. Those 2 envelopes contain the notice of hearing, the civil summons, and the complaint in this action that's before the court. According to the notice that I received, I'm real early. The notice that I have received says the notice for the day is at 9:30 this evening. So I decided I would come early just to be thinking that was a typo. Immediately when I received these papers, called Mr. Casper because that's the only name I'd seen up to that point in time of a person I could contact besides the Honorable Secretary. I left an extensive telephone message with him. Never got a call back. So I sent another email to him transmitting a copy of the memo and the notice I had sent to the Honorable Dr. Cohen to advise him that they had the wrong party in this matter. And that we would hope that they would get the right party and I wouldn't have to go to any more trouble because I do not represent technically Ace Speedway Racing Ltd. Or 1804-1814 Green Street Associates Limited Partnership, and I've not been employed or engaged to do that. I'm only here for the limited purpose because of the bar rule, because I'm the registered agent, but unfortunately I should have withdrawn years ago. Unfortunately, the Secretary of State didn't administratively dissolve that entity when it should have, well, failure to file annual reports. So it is a record. I checked it. It's still there as a record. I'm still listed as a registered agent, and that's why I'm here. Let me further state as a procedural matter, it's been mentioned this morning, that emails were sent, I presume to me, when he said it was Ace Speedway Limited. I have not received any email from anybody in the state. I'm the one that's been corresponding, calling, and getting no response from the state at all. Now, with regard to 1804-1819, Green Street Associates Limited Partnership. The first time I had received any notice about that was late yesterday afternoon with that white envelope coming to my office with that written on the front of the envelope, and then the summons, the notice, and the complaint contained in the envelope. And I called Mr. Casper, left an extensive telephone message, followed up with an email, and have not received any response whatsoever. I do not know if I'm the registered agent of 1804-1814 Green Street Associates Limited Partnership. I've tried, and my office hasn't been able, at this point when I left this morning, to come here to find out if that's still the case or not. But I'm presuming that I am. And so my limited appearance is only to this court with the request that you note, because of the bar rules 1.2, I'm here, but I'm not representing either one of my former clients. I'm not speaking for either one of my former clients. My only duty is to inform the court of the procedural matters that I find myself entangled as a former registered agent and still evidently listed as a registered agent of the corporation. And I did want to let you know that I have endeavored to perform my ethical duties. I've tried to contact my client, who's not available because of the virus. From his assistant, I found out that his entity, Ace Speedway Racing Ltd., has nothing to do with Ace Speedway or its operations here in Alamance County, and hasn't for a number of years. Now, that has been communicated by me as best I could to the Honorable Secretary Cohen, let her know that before this process got out of hand. Followed up yesterday with obviously nothing being done about my communications, and I'm still getting served as Ace Speedway Racing Ltd. As though it were the operating entity of Ace Speedway, and have called and left a message to Mr. Casper and followed up with an email. And again, he is saying that there was some emails sent out. I've never received one email, not one. The only thing I've received were 2 envelopes, plain white, one after hours on Monday evening and one yesterday evening at my office that had the complaint, the notice at 9:30 for this evening, and the summons. So I'm here, and I've tried to explain to the court the procedural facts as I know them, and I would request that the court in its infinite wisdom would allow me to withdraw as my limited appearance.
All right, thank you, Mr. Long. Mr. Casper, you want to address any of that?
Yes, want to say that I'm sorry about not getting back with the phone call. I did not receive the message, and it could be because I was not in the office yesterday, and so didn't see until at the end of the day when the voicemail might have come in, but I do apologize for that. As to why we named Ace Speedway Racing Limited and 1814 as defendants in the matter, first of all, I would note that if you look at the abatement order, section 1 of the declaration, which is I think the third to last page of the complaint, it says, for purposes of this order, Ace Speedway is defined as Ace Speedway Racing Limited, a North Carolina corporation, and any other corporation, business entity, proprietorship, or individuals that own or operate the facility currently known and operated as Ace Speedway in Alamance County, North Carolina. As I said earlier, we did not know who operated the facility there. Mr. Kitchen, as I said, did not disclose the name of his clients or who operated the facility. We also knew that the land was owned by the 1804 to 1814 Limited Partnership, and Mr. Long is listed on the Secretary of State's website as the registered agent for it. So we were trying to provide notice to anybody that we could, but we meant for the abatement order to encompass anybody that's operating it. We just didn't know who it was. And so that definition in the order is broader than just Ace Speedway Racing Limited. It is anybody who's operating it, which would include Mr. Kitchen's clients, as well as the entity that owns the land. Again, we felt compelled to include Mr. Longest's former clients in this matter because they previously operated it and because the land is still owned by the partnership, which he is the registered agent for. And again, I do apologize that I didn't receive your message and get back to you yesterday.
Right. Thank you. All right, so I've got a brief that was handed up this morning, and several cases that were handed up this morning, so I'm going to be at ease while I review those. As I stated earlier, I had already early this morning reviewed the complaint and all the exhibits. And it might be worth saying just for the record, Madam Reporter, we're in the Commissioner's meeting room, not a normal courtroom, and the reason being that there'd been some public interest in the case where our office had some contact from some news media. And we in Alamance County have been very diligent in trying in our court system to socially distance all of our courtrooms and have very limited seating for folks. And this particular courtroom, which is being used as a courtroom today, this Commissioner's meeting room, only seats 10 to 13 people. And as you can see, with court personnel, parties, and attorneys, we've pretty much got it filled in a socially distant, responsible way. What we did late yesterday was, with the county's assistance, and I want to say how much I appreciate Mr. Haygood and all the county officials. We got notice out and gave several different ways for the public, anybody who had an interest in this case, because as you all know, our courts are open. North Carolina's courts are open, and under our going all the way back to the forming of our state, we have open courts. And the way during this COVID pandemic that we've been able to honor that is through, in this case, a live stream that's going on right now of this hearing that anybody who inquired or looks on various outlets, Facebook outlets and others, both the county, the administrative office of the courts, the clerk's website, several places were listed. And I see Ms. Edwards, our elected clerk, here as well, and Sheriff Johnson. I want to recognize and appreciate y'all being here. Ms. Edwards and her office helped get all of that information out. So this matter is being broadcast so folks can see it who have an interest in this, both the public at large and the media. All right, so with that, I say all that to say that we're going to have some downtime because I need to go back into chambers and read each of these materials. So, Mr. Sheriff, let's just be at ease while I do so.
Court will be at ease.
All right. I have had time to review all of the materials and consider all the arguments of counsel. I certainly want to compliment all the lawyers on an excellent handling of the case and excellent presentation. And as we discussed, this is just the very beginning of this case. It was just filed yesterday afternoon, and this is the first hearing in this matter. I'm going to make a couple of observations that I think need to be said, and then I'll share what I believe the correct legal ruling is. We all know, I mean, it's trite to even say it, but we're in incredibly unusual times. And I think our government, federally and locally and state government, has had enormous challenges and continue to have enormous challenges in trying to deal with something we've never dealt with in any of our lifetimes. I mean, a pandemic, a global pandemic of this nature has never happened in at least 100 years. And it is stressing our whole society. I mean, that's just the reality of it. And I would imagine that Governor Cooper and Secretary Dr. Cohen and other state leaders probably are very stressed every day as this thing continues to evolve and move in trying to make that delicate balance between essentially a true public health emergency and the economics of trying to have an open society and people trying to earn a living and support their families. And there's just an awful lot of stress around all of that. And I'll just say this. It really makes me sad how sort of contentious some of this stuff has become among people in our society. You know, we are all Americans, and I keep just shaking my head sometimes that we've just got such an us versus them mentality in our nation right now that is so regrettable. And I am certain that governmental leaders across this country are trying their best, just as our local leaders are, to keep our people healthy, but to also let people try to work. And I don't think anybody takes delight in having a business not being able to have people come to their establishments, Ace Speedway included. But it is clearly, and Dr. Cohen's verified complaint and all the accompanying documents make it very clear that there is an imminent health hazard in our state and in our county. I think the numbers in North Carolina were something like 1,000 cases and I think 23 deaths. No, that was in Alamance County, 23 deaths. I think statewide, I forget the numbers. I read them all. I do know the ones that keep just are heartbreaking. And when you look at our nation as a whole, we've had over 2 million cases apparently, and more than 112,000 deaths. And we're not at the end. So it's a serious matter. And I was reminded of something I was thinking about the other day that I heard somebody say very beginning of this pandemic, maybe the first couple weeks. Somebody made the comment, they said, you know, our grandparents and our great-grandparents, they went off to Europe to fight Hitler, and they went off to save the world. All we're being asked to do right now is to try to stay home and stay safe and not spread a disease. And, you know, and I think early on people were more conducive to that. I think people are getting quarantine fatigue, as I've seen it phrased. I think people are, want to get back to normal, but we're not there yet. And I think that our leaders should be applauded for trying to do what they can to do that very delicate balancing act between our economy and the public health crisis and the hazard to our public health. I wanted to just really struck me this language by Chief Justice Roberts from this South Bay case from just a couple weeks ago and it's worth reading this. And it was read earlier. The precise question of when restrictions on particular social activities should be lifted during the pandemic is a dynamic and fact-intensive matter subject to reasonable disagreement. Our Constitution principally entrusts the safety and health of the people to the politically accountable officials of the states to guard and protect. When those officials undertake to act in areas fraught with medical and scientific uncertainties, their latitude must be especially broad. I think that really summarizes it. I think that's where we are, and I think based on all of the materials that I've reviewed and the arguments of counsel, the appropriate ruling is that I'm going to grant a temporary restraining order. I'm going to restrain and enjoin a Speedway and any of the entities associated with it from holding any races until we can have another hearing in this matter. I asked the attorneys to come back to Chambers so I could discuss scheduling with them and to inform them of my decision. We are going to have a return hearing on this a week from tomorrow, June 19th, 8 days from now, at 9:30 in the morning, and it'll be in this room because, again, this is the only room in our courthouse that's set up for the live streaming so that anybody in the public who wishes to attend can watch watch the court in session. I will say, you can see the limitations on this room. I'll ask the parties if y'all will discuss as you get into next week how many witnesses you may have and communicate that to me, because we may have to stagger witnesses. I don't know how many you may have. I don't know how many you may have. But we only have room in here for just a limited number of folks to socially distance. So we may have to stagger those depending on how many witnesses would be here. All right, so I'm going to, Mr. Clerk, I have, there were a couple of corrections that I wanted to make to a proposed order, and I did. So I'm going to ask you maybe if you can help get copies for each of the parties, but I'll ask you to file it, okay?
Yes, sir.
Mr. Clerk. All right, so anything further from either side? From the plaintiff's side, from defendants?
No, Your Honor.
All right, so Mr. Schiff, let's recess this court.
Court will be in recess.
Time.
75.
He just started.
We're live.
Sorry you guys had to sit there for that whole time.
Tall guy, beard, twins, purple hoser. Dude, perfect's in overtime. Tall guy, beard, twins, purple hoser. Now we're heading on to overtime.
Welcome to Overtime 16. We got a great show for you guys today.